Hello, my name is Josh Blackman, and I am the president of the Harlan Institute. Welcome to the 2020 Harlan Institute Ashbrook Virtual Supreme Court competition. This is our Elite Eight round with our top 8 teams, and today we're arguing the case of Torres versus Madrid. For the petitioners, we have Stephen and, I'm sorry, I flipped it around. For the petitioners, we have Campbell and Gabriella from Austin, Texas. And for the respondents, we have Stephen and Benjamin from Connecticut. I am now going to turn it over to my good friend, Chris Riano, who will be presiding.
Excellent. Thank you so much. My name is Christopher Riano. I'm the president for the Center for Civic Education. I'm on faculty at Columbia University. And I want to turn it over to the petitioners to have a chance to introduce yourselves and kick off.
Thank you, Your Honor. May it please the court. My name is Gabriella Lovins, and along with my co-counsel, Campbell Collins, I represent the petitioner, Roxanne Torres. Ms. Torres was shot repeatedly. She was injured so severely that not only was her arm paralyzed, but she had to seek urgent medical care. This application of force was a seizure under the Fourth Amendment, based both on historic common law and this court's precedent. Would the court like a brief statement of the facts?
Yes.
On July 15th, 2014, petitioner Roxanne Torres parked in the lot of an apartment complex. She was approached by respondents, 2 police officers who were not in uniform, instead in tactical gear. And as they approached, Ms. Torres, who had used methamphetamine, ran to her car and got into it. While she accelerated to get away from the 2 police officers, whom she believed were carjackers, both officers fired at her repeatedly, hitting her twice in the back. The district and appellate courts did not consider whether the force used was
Counsel, how long did she drive and how far did she get after being shot?
Your Honor, she drove a total of 75 miles to get to a hospital once she was shot. However, because under the common law, a physical force seizure requires only the application of force with intent and not submission by the suspect.
But doesn't Hodari require submission?
Well, Your Honor, Hodari dealt with 2 types of seizures, both the physical force seizure, which does not require submission, and the show of authority seizure, which does require submission, but does not require contact.
Why should we differentiate between the 2 like that? Why shouldn't we require submission for both?
Well, Your Honor, because in the common law, there is a tradition of a physical force seizure, which can be just a mere touch and does not require submission.
Yes, but counsel, in Hodari, we said that you can have a physical force seizure, but once the suspect breaks away and is running, there's no continuing constructive seizure.
Yes, Your Honor. However, the seizure in this case was the force applied when the bullet hit Ms. Torres. And you're correct.
Why is that different than the force applied when I grab a suspect and he breaks away and runs away?
It's not different, Your Honor. That was still a seizure under the common law definition.
So what made it different? The mere fact that he was stopped for a brief second?
Well, under the common law, the mere application of force, regardless of what happened after that, as soon as any type of force was applied, that was a seizure. Now,
but in Hodari, when we talked about the common law, didn't we emphasize the taking of control? I mean, wasn't there a citation to prize cases where it was determined that firing at a ship did not qualify as its seizure for purposes of prize because the ship had not yet been taken under control? So in Hodari, the 2 hypotheticals we addressed, one, you had physical control as a result of the application of physical force and then loss of control. And the other, you had a show of authority followed by submission. Did we address a situation where an officer applied physical force and didn't gain possession?
Yes, Your Honor, that was addressed in Hodari. The Hodari court specifically stated that to constitute an arrest, the quintessential seizure of the person under our Fourth Amendment jurisprudence, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. So in this case,
But counsel, didn't we also say to say that an arrest is affected by the slightest application of physical force despite the arrestee's escape is not to say that for Fourth Amendment purposes, there is a continuing arrest?
Yes, Your Honor, there is not a continuing arrest as the seizure occurs the second the bullet hits or the second the officer makes contact with the suspect and does not continue after they've made contact.
Well, then
So is
why,
she continually with?
why is there no continuing arrest? Answer that question.
Well, Your Honor, because the seizure is not necessarily the possession in this case, but under the definition of a physical force seizure, which is based in the common law rules of bailiffs and defendants, the seizure was the application of force. So as soon as
Then why isn't shooting naval artillery at an enemy ship not sufficient to qualify as seizure so long as it keeps fleeing?
Well, Your Honor, because the common law did make a distinction between a seizure of objects and a seizure of person, because they found that applying physical force to a person violates personal security in a way that simply applying physical force to an object does not.
Where's your authority for that?
Well, Your Honor, in Genner v. Sparks, a 1704 English common law case, the court held that if the bailiff had but touched the defendant, even with the end of his finger, it had been an arrest. And later, the court interpreted this to mean that it was based on the Fourth Amendment idea of personal security. In Terry v. Ohio, this court held that the utmost violation of personal security is violating the sanctity of the person. And
What is the essence of the prohibition against an arbitrary seizure? What is it protecting you or your property from?
Well, Your Honor, the Fourth Amendment specifically states the right of the people to be secure.
Understand that, but what is it protecting you or your property from? The government doing what? Just touching it or depriving you of your autonomy over it?
Well, Your Honor, in the common law, simply touching a person could be depriving them of their autonomy.
Could be.
So the police officer walking down the street, just bumping into me with, non-consensually, they touched me. So is that a seizure?
No, Your Honor, because that brings us to the second requirement for a physical force seizure, which is intent to restrain.
But let's go back to the first one. I'd like to know whether or not you're arguing that your client was seized the entire time she had the bullet in her. Or are you arguing that the minute the bullet hit her body, that was the seizure, and then it ended, and then she was fleeing?
Yes, Your Honor. The minute the bullet hit her, that was the seizure, and then she was fleeing. Because the bullets were fired with intent to restrain her, that is what made it a physical force seizure. If they had hit someone else that they did not intend to restrain, that would not have been a seizure. And if they had touched someone with the end of their hand, but not meant to restrain them, that person had not been seized.
Why are you so quick to concede that her flight after being shot does not qualify as a continuing seizure?
Your Honor, because the seizure was the force, and the force stopped when the bullet stopped penetrating her.
I've never been shot, but having a bullet in me would seem to be a continuing application of force. And I hope I never have to experience it, but I doubt it's trivial on the part of the person who's shot.
Well, Your Honor, going back to the common law, in the common law, a physical force seizure was the application of force. And while we don't have a common law analog to a police officer shooting someone with a bullet, because there wasn't that type of police force at the time of the founding, the closest comparison we have is bailiffs finding defendants who were trying to not pay their taxes. And in that situation, what the common law states is that just touch was a seizure.
Wait a second, we have a lot more. I want to go back to common law and say we have a lot more in front of us between 1704 and now. What we have Mendenhall, right?
Yeah, so I would just want to tack on to that. I'm very impressed with your expertise on the common law, but I'm not so sure that I'm as that the appeal of originalism is as strong for me as it was for Justice Scalia when he decided Hodari. There is more jurisprudence. I get that the common law informs us, but you're arguing as if it is dispositive of this issue.
Well, Your Honor, we also have other seizure cases, like you mentioned. Mendenhall specifically is distinguishable on its facts, as it was a show of authority seizure dealing with whether consent if there was consent to the search, was it really a search and seizure under the Fourth Amendment? So this is quite different from a physical force seizure like this. Now we also
but Mendenhall was really about seizure and whether Ms. Mendenhall, a reasonable person in Ms. Mendenhall's circumstances, would feel what they could leave. And if they felt like they could not leave, then that constituted a seizure. Yes, so your client obviously felt free to leave because she did for 75 miles and over an hour.
Well, Your Honor, this is what makes the application of Mendenhall confusing in this case. Because what Mendenhall found is that the presence of a weapon or the application of physical force could be a factor that made someone not feel free to leave. But Mendenhall leaves up in the air whether that means that the person actually has to not leave, whether that means a reasonable person would not have felt free to leave. But
Counsel, it strikes me that you may have just contradicted your position, because you said that Mendenhall provides a principle that the touching may indicate a seizure. Earlier in your argument, you're trying to persuade us that a touching with intent to seize is ipso facto a seizure. Which is it?
Your Honor, if there is intent to restrain, it is a seizure. However, Mendenhall, again, was not dealing with physical force seizures, but rather show of authority seizures. So it is not fully applicable to our case today.
And Mendenhall furthermore never addressed intent.
Now, should we wrap up?
Yes, please.
Now, in conclusion, because common law defines physical force with intent to restrain as a seizure, and because this court should not make the protections of the Fourth Amendment less than they were at the time of the founding, Ms. Torres was seized in a Fourth Amendment sense.
We pray that this court will reverse the decision made by the Court of Appeals.
Thank you, counsel. The respondents. Please begin when you're ready.
Mr. Chief Justice, may I please the court? The question presented today before the court is whether or not an unsuccessful attempt to detain a suspect by use of physical force constitutes a seizure within the meaning of the Fourth Amendment. We answer this with a resounding no, and we urge this court to affirm the 10th Circuit's ruling in this case, Torres versus Madrid, that no seizure occurred.
Mr. Shi, do you believe that that's how your opponents have framed the issue? Because it strikes me that they framed it quite differently.
No, Your Honor, they rely heavily upon the dicta of Hodari D and also the common law, which actually does not support their argument. In fact, we believe that the fundamental qualification for determining a seizure lies on whether the freedom of movement is restricted.
Okay.
And we can see this in Brooks v. Gainsley.
Yeah, so in the 10th Circuit Court's decision, they referenced Brooks v. Gansby, a case in which Officer Gansby shot Mr. Brooks, who fled an unsuccessful attempt to detain him. In Torres v. Madrid, the 10th Circuit Court found the officer's force failed to control the ability to evade capture or control. And Brooks v. Gansby said a seizure requires restraint of one's freedom of movement, which is essential to the framework by which we are judging a seizure. Now, this same restriction of movement requirement is also present in this court's unanimous decision in Broward v. Inyo County. The ruling for Broward states that there needs to be a termination of movement in order for procedure to occur.
But counsel, wasn't that limited by its facts, as all of our cases are? Because in that case, the individual ran into a police barrier, and so therefore the facts were governing why they said there was that complete termination, weren't they?
Yeah, so the facts of that case were quite extreme. However, the holding of termination of movement is present.
Well, counsel, you don't find the facts in this case to be quite extreme?
Yeah, they are. And as a matter of fact, this termination of movement framework works perfectly in the context of this case. As I'm sure we're aware, Torres drove away from the police officers, left her car and stole a new one and continued to drive over 75 miles. So her movement was uninhibited.
Mr. Blank, even if you assume that we accept your proposition that there has to be some deprivation of the individual's liberty, why should we restrict it to complete termination of movement? Do you think an individual with 2 bullets lodged in their body has complete autonomy over and liberty? Or do you think that the bullets in the body in a very real sense constrain the individual's freedom of movement and liberty?
That the way that's described doesn't actually it's a reasonable point. However, the bullets in the body, what matters is whether or not they're able to successfully restrain movement. In Torres's case, bullets were not enough.
But Mr. Blank, did the plaintiff here drive to the mall to go shopping, or was she compelled to drive to a hospital to seek treatment?
Your Honor, she was actually trying to get away for a long time, and her movement she was able to get 75 miles, and ultimately, while she had to go to a hospital in the end, she had a very long period of time during which she.
Why did she have to go to the hospital, Mr. Blank?
What could you repeat?
I want to add on to my co-counsel. The reason why she went to the hospital is because she had suffered some blood loss. However, they were not fatal injuries. And in fact, during that process, Torres was able to steal another.
Okay, counsel, I would like to go back to a different case. In the Jones case, we decided that non-consensual touching of a car, of a Jeep, the placement of a GPS device on the undercarriage of a Jeep where the Jeep owner and driver couldn't even see it, with the intent to obtain information, was a search. I know this is a seizure case, but it was a search. But because the court labeled that, we labeled that a search, that then was governed by the Fourth Amendment, whether or not it was reasonable to place it without a warrant. So if my Jeep gets protection from non-consensual touching by police with an intent to search, why shouldn't my body get protection that non-consensual touching, a trespass on my body, like being shot because a projectile is an extension of the police body, with intent to stop me? Why shouldn't that place that? Why shouldn't that be on the Fourth Amendment spectrum as well, and therefore be analyzed under the reasonableness spectrum or criteria?
So the cops were actually acting in active defense because Torres was going at her, and in that case, it was a reasonable application of.
Well, I don't care about whether it was reasonable or not. I'm worried about, should we be in the Fourth Amendment world or not? Right. And if my Jeep gets to be on the Fourth Amendment world because of a non-consensual touching, why shouldn't my body be on the Fourth Amendment world because of a non-consensual touching? Doesn't that go back to the very values the Fourth Amendment was written to help protect?
Or does motive distinguish them, Mr. Shi?
Yes, Your Honor. We believe that the intent of the Fourth Amendment was to protect the personal liberty of someone's body, and that personal liberty is.
Let me interrupt you. The intent of the Fourth Amendment's prohibition against what?
Against any infringements upon the personal liberty of someone to move away from a scene.
No. Maybe I didn't make the question clear. I'm confused about your statement of the purpose of the Fourth Amendment. It seems to me the purpose of the Fourth Amendment was dual. One was to protect the possessory interest in yourself and your property. The other was to protect the privacy by restricting search. What I'm asking you, Mr. Shi or Mr. Blank, in response to Justice Van Landingham, is how would you distinguish or can we distinguish the Jones principle from what happens here? Because if we can't distinguish them, then Justice Van Landingham has put a pretty significant obstacle in the path of your argument, which is there was a physical touching by the police of the body that's protected by the Fourth Amendment.
Yes, Your Honor, we can clearly distinguish the two situations. In fact, the purpose of a seizure is to stop someone from moving away from a scene.
Where's your case law for that, right? Because isn't it about the personal autonomy? Isn't it about liberty and security in one's body? Why does it have to be just the cessation of movement?
So actually, the Hodari D case does offer a definition here, and it's the same definition that's present in Samuel Johnson's Dictionary of the English Language from 1785 and Black's Law Dictionary from 2019, which is that a seizure is an act of taking possession of a person, and one is in the police officer's possession when their movement is inhibited. And
why can't an attempt qualify? Isn't this, and you would agree this was an attempted? You would say this is an attempted seizure, not a seizure.
Yes. So Hodari D actually says that specifically says that an attempted seizure is not a seizure. It makes that specific holding, and
only for a show of authority, though, not for physical force. It never distinguished when is the application of physical force a seizure, right? Or else we wouldn't be here today. We would have said asked and answered.
Yes, Your Honor. That's why we can look at Broward v. Inyo County, which indicates the use of a physical force to terminate the movement of a suspect. And it specifically mentions the termination of movement in Broward v. Inyo County. And
because the movement was terminated in that case, right?
What is the policy significance if we adopt your view of what qualifies as a seizure? Because it strikes me that what we're basically saying is a police officer is immune from constitutional scrutiny when he employs deadly force, actually hits the victim, but the victim doesn't immediately submit. That to me, beyond common law discussion, that to me seems to be a pretty troubling policy position in the world we're living in today, when the use of firearms is such a prolific aspect of policing.
So we believe that they should not be, that they would obviously be tried for their force under other claims, such as a 14th Amendment claim. However, whether or not it's an actual seizure, which is relevant to the excessive force claim that Torres here files, it's solely based on this framework of a restriction of movement. Now, to try and expand upon that a bit more, we'd like to talk about the Hodari D decision and the excerpt from it, which must be treated as dicta. Specifically, there's this point that the petitioner always comes back to reference, which is about how they claim how Scalia lightly references unsuccessful force to restrain movement. However, this can be thoroughly debunked through precedent that we mentioned. And also, the Hodari D decision is in and of itself self-conflicting, because the possession point directly goes against this whole unsuccessful bit that Scalia mentioned.
How did we go against that? What we held was that when Hodari was grabbed, he was in fact seized, but when he broke away, there was no continuing constructive seizure. So the fact that the seizure ultimately was unsuccessful didn't mean there wasn't an initial seizure. The question was whether he was seized when he discarded the narcotics, which would have rendered the argument that the narcotics were the fruit of an illegal seizure. Are you arguing that we concluded that when he was first grabbed, he wasn't seized because he broke away?
No, Your Honor. We believe that the seizure occurred when there is a restriction of movement. However, in Torres versus Madrid, there was no restriction in movement, because even when the bullet hit Torres, she continued to drive forward. And
where in Hodari did we conclude that when Officer Petrozo first grabbed him, he effectively restricted his movement? The facts of the case indicate that Officer Petrozo attempted to effectively restrict his movement. That attempt failed because he then fled. Your opponents are not arguing that their client was seized the entire period of flight. They're arguing that the attempt to seize by the application of physical force is identical to what Officer Petrozo did initially in Hodari, but wasn't addressed in Hodari because it wasn't a decisive point.
Your Honor,
the seize was not an actual seizure, and that's what we really want to come across, and that's what Hodari D holds. The part from Hodari D about unsuccessful
Mr. Blank, in Hodari D, what was the critical moment that had to be assessed as a seizure? When the officer grabbed Hodari, or when Hodari discarded the narcotics from his pocket? What was the critical moment?
It was the grab.
So
it stated that in the holding that there must be a taking of possession for a seizure to occur. So when the suspect, Hodari D, is grabbed, that's when the seizure occurred, because the officer had control over Hodari.
But when that bullet hit Miss Torres's body, wasn't that analogous to being grabbed at that very moment?
And Mr. Shi, he obviously did not have control over Hodari, because if he had control over Hodari wouldn't have been able to run.
Yes, the additional section attached to it is a hypothetical situation. In the actual Hodari D ruling, Hodari D was successfully tackled and successfully seized at that moment. What the justices attached was a hypothetical that did not actually occur based on the facts of the case.
Now, we'd like to mention that we weigh Supreme Court precedent over common law because of the long body of jurisprudence refined by the US judicial system. However, even if we do take into account common law from the 17th century actually does affirm our framework interpretation of Torres v. Madrid. If we look at the 1604 Countess of Rutland case, there was an application of indirect force through a mace. And here the petitioner uses a connection between the common law definition of arrest and how that's a seizure. However, it's important to note that in this case, there was actually a submission to authority when the countess was compelled to be taken to the compter. And this supports our framework, once again, of either of a submission to authority, which is in essence a termination of movement. So even if you look back at old cases from then, or as we pointed out, the 1785 definition of the word seizure, this all just points to this whole idea of a taking of possession being essential to the actual
seizure. Mr. Blank, I want to go back to the question I asked you earlier. If we agree with your interpretation of seizure, then obviously a police officer who shoots a suspect intending to seize and fails to do so has not implicated the Fourth Amendment. Your response was there are alternate remedies for example, the 14th Amendment, do you think that the protection of the individual from an arbitrary use of force is analogous under the 14th Amendment as it is to the Fourth Amendment, or will the protection be diluted if we don't apply the Fourth Amendment standard?
The protection won't be diluted. It'll simply just be tried as something that shocks the conscience under the 14th
So
Amendment.
the test of reasonableness is identical under the due process standard and the Fourth Amendment standard?
No, the test is not identical here. The test for the Fourth Amendment, the test is whether or not it's an actual seizure.
Not whether it's a seizure. The test of reasonableness. That's what I'm getting at.
How about this, counsel? Would you rather have someone's grabbing of you, right? Someone grabs you on the street without your permission. Would you rather have that grabbing judged for its wrongfulness or rightfulness under a reasonableness standard, or whether or not it shocked the conscience that someone grabbed your arm tightly?
Well, on both cases, this grabbing of an arm would not be an excessive force ruling, and so the case would not lead to an excessive force ruling.
But would you want someone, if someone's determining whether or not someone grabbing you non-consensually is wrongful or not, would you rather have them apply a shock the conscience standard or a reasonableness standard for deterring them from doing it?
You would agree, Mr. Shi, that under the Fourth Amendment, the question is whether there was good cause for the effort to seize.
So
you don't think that's the same standard of compliance as we would apply under the Due Process Clause, do you?
So yeah, this is a great question, and I'll finish with this. The reasonableness would actually be tried really by lower courts, and when you're filing a claim that has to do with these constitutional amendments, you have to use tried and true test. And in the case of a seizure, our side provides a clear test about determination of movement. So if you want to go for the side that is consistent with constitutional precedent and common law and long-standing definition.
Mr. Blank, however we decide this case, we're providing a clear test. It doesn't matter whether we agree with you or disagree with you. There will be a clear test of what qualifies as a seizure when an officer uses a firearm in an effort to stop somebody.
Of course, Your Honor.
Thank you both very, very much. Any rebuttal from the petitioners?
Yes, Your Honor. May it please the court. We will address three specific points made by the respondents. First, that the freedom of movement is unclear and needs to be harmonized with Hadaredi and common law. Second, that the founding era definition encompassed force without submission. And finally, that an attempted physical force seizure is different from an attempted show of authority seizure. First of all, the freedom of movement or requiring restricted freedom of movement is unclear and begs the question, was Ms. Torres seized because her arm was paralyzed? Her freedom of movement was clearly restricted under that definition. She could move her arm about as much as she could have moved it if she were in handcuffs. Now, respondents also rely heavily on the case Brooks v. Gainesville, a 10th Circuit case. As a 10th Circuit case, it has less precedential value than Hadaredi, regardless of whether or not Hadaredi was indeed dicta. Now, we can also, when we look at these circuit cases, we see there's actually a circuit split. We have Brooks v. Gainesville, which requires submission in a physical force seizure, but we also have Carr v. Tantangelo, which was an 11th Circuit case and held that although Carr was not immediately stopped by the bullet from Officer Fortson's gun, he nevertheless was seized within the meaning of the Fourth Amendment when the bullet struck or contacted him. So clearly, we have some confusion in the lower circuits as to whether or not to follow a physical force seizure requiring submission or not requiring submission, which is why we need a clear rule in this case. Our rule provides a bright, clear line for officers in the field and allows them to know, if I make physical contact with this suspect, I am seizing them under the Fourth Amendment.
Counsel, if we rule against you, we're providing, it's the same point I just made to Mr. Blank. We're providing the identical clear rule. If you don't take physical possession of the property or the suspect, there is no seizure. So the clear rule argument is an argument that cuts both ways, doesn't it?
Yes, Your Honor. However, the respondent's rule requires either restriction of freedom of movement or even termination of freedom of movement.
Why
And
is that so complicated for a police officer to know whether or a judge to know whether somebody's been seized? That's not complicated.
Well, Your Honor, if Ms. Torres's arm was paralyzed and therefore her freedom of movement restricted, why wouldn't this qualify as a
They're
seizure?
not arguing for a restricted freedom of movement. They're arguing for a deprivation of freedom of movement standard. So they're acknowledging that you could have a situation where someone is shot and their freedom of movement is qualified, but it's not terminated. They use the word terminated in their argument several times. That is a clear rule.
Yes, Your Honor. With this rule, it's based more on the common law and this court's precedent, so it makes more legal sense to follow our rule. Now, also, we do have Brower, which seems at first glance as if it could be.
You're running out of time, so I want to get your response to the question I asked Mr. Blank. What is the policy implication of adopting their interpretation of seizure for purposes of the perception of the American people as to the integrity of the law as it relates to police use of force? That's something we should not be ignorant or dismissive of.
Well, Your Honor, that is correct. And this case, in fact, fills a gap between cases that would not rise to the level of the shocking the conscience standard under the 14th Amendment, but are still violations of personal security and still should be qualified under the 4th Amendment. And under this rule, any application of physical force by a police officer with intent to restrain that person is subject to scrutiny under the 4th Amendment. And therefore, the application of force with intent to restrain rule provides more protection for citizens against excessive force by police.
It also provides
Do you think most citizens would be surprised to learn that a police officer is unconstrained by the 4th Amendment if he shoots them, but they run away?
Yes, Your Honor, because this bases the 4th Amendment on the response of suspects to the actions of police and not those actions of police in the first place. And since the founding era, the 4th Amendment has been based on what police do and not what citizens do afterward. It was, in fact, based on overreach by British officers in the first place. So this rule provides more legal protections for citizens under the 4th Amendment that they wouldn't get from any other constitutional recourse.
Thank you for your answer. It was excellent.
Thank you, Your Honor. Now, in conclusion, the use of force with intent to restrain is the rule that should be chosen to define seizures for police officers. When the police officers invaded Ms. Torres's body with bullets and paralyzed her arm, they intended to restrain her. Under the respondent's test, only a permanent termination of movement resulting in only a permanent termination of movement is a seizure, and here that may mean death, which can't be what the founders intended. Therefore, we pray this court will reverse the judgment of the Court of Appeals.
Thank you. Wow.
Yeah.
Wow.
Wow.
Wow. Everyone back on camera. Come on, everyone. Wow.
Campbell Collins,
Congratulations.
are you the advocate with the dark hair or the blonde hair?
That's me, I'm Campbell.
I'm Gabriella.
That answer to to what I asked you at the end was off the chart.
Yeah,
That
that's
was
great.
Supreme Court quality advocacy.
Yep.
That was all around. That was truly remarkable. You guys had a hot bench today. You guys went to hot benches where the questions coming at you. This was smoking hot. Wow. I couldn't answer Jeff's questions. I've been working with the guy for a decade. I don't know how to answer his questions. That was fantastic. Again, I've been doing this competition now for about 8 years. I cannot believe consistently how 16 and 17 and 18-year-olds are pulling this off. These are the same questions you would get if you were a third-year law student in a moot court final round for a national championship, and you'd win. You could walk into a moot court tomorrow in any law school in the United States. Hell, you could walk to a Supreme Court tomorrow. I think you could do this. You go to any Court of Appeals.
You guys should be so proud of yourselves. I mean, the depth of knowledge, you're coming at us with the Countess of so-and-so. I'm like, whoa. I mean, the depth of knowledge and the fluidity with it, that you're not like pausing.
Yes, the comfort level was off the charts. I mean, you knew your material inside and out. You anticipated tough questions. You didn't let yourself get thrown off track, even though we were trying to get you thrown off track. That was incredible. That was practicing attorney is at the appellate level caliber.
Mm-hmm. Yeah, and great teamwork too.
Yeah, great team. Rachel and I are both former military officers, and I will tell you that advocacy is like a commander in battle. Your job is to seize and retain the initiative and keep the opponent off balance. And that's what the judges are trying to test you on.
But what do you mean by seizure? What's a seizure?
Yeah, we're trying to throw you off balance so we take over the argument, and none of you let us do that. None of you were able to defend against that and stay on your track. And that's really the great art of advocacy.
Mhm.
And Stephen, I love the fact that, I mean, you just kept plowing through, and Professor Korn had to interrupt you several times. So that's good, because you were trying to make your point.
Yeah.
But you were still responsive, because there's sometimes going to be a fine line there, but you were still responsive. You answered the question, then immediately got on what you wanted. That was well done. And Benjamin, I love the way then again, that's great teamwork that Professor Korn mentioned. You picked up on where the judges were going, because sometimes as the co-counsel, you can hear that better than your counsel. And you filled in where maybe, where we wanted to go. And I thought that was really well done. That was very adroitly done.
Fantastic. Chris, want to add?
I thought that was amazing. I mean, I literally could not have seen something similar, and have not seen something similar in a long time, even with my college or law students. I mean, that's one of the hardest things to do. And you have 3 former prosecutors on this bench, is to own the room, and each of you own the room. And that was a very, very incredible performance, literally all 4 of you. And you should be very proud of yourselves.
Yeah, I hope all of your parents are proud. I hope all of your coaches are proud. This was really something special. I mean this. You could walk into an appellate court tomorrow. Lawyers don't do this well in appellate courts. They're unable to answer questions the way you were, and they do this for a living, get paid a boatload of money, and they can't. It's true. It's true. I hope all 4 of you sincerely consider law school. I don't know where you are in your careers, but college is ahead of you, and then law school is not that far down the road. It's I know you two in Austin, so if you ever want to come visit Houston, Jeff and I, you're welcome to visit our classes anytime.
Way nicer than Austin, I'm telling you.
It's a lovely city. But that was
Los Angeles is even better.
Oh, look at her.
And for you 2 East Coasters, having grown up on Long Island, there really is a world beyond a 200-mile radius of New York City. So
I'm from Staten
I've
Island.
never seen it though, Jeff. I've never seen it. I've never seen that world.
I'm telling you, I mean, when I grew up, like driving 4 hours to upstate New York, I might as well have been driving to Siberia.
Yeah, I grew up in Staten Island. I'm far from home, but I'm very happy here. I want to give a chance to the students to ask questions of us, because this is you have 3 prosecutors, you have 2 JAGs. Chris is the head of a national civic organization. This is a very good opportunity for you to inquire. So please go ahead.
Go ahead, Stephen.
Yeah, I was wondering how you guys managed to keep like a completely stoic, like a stoic,
Demeanor.
Yeah, exactly. Yeah, like a stoic demeanor when firing away these questions.
Here's the deal, Stephen. If you become a law student and a lawyer, what you're going to learn very quickly is that you're a servant. You're an agent, right? You cannot allow anything to become personal or to become too emotional. I'll give you a specific example. Do you guys remember about 10 years ago, a guy named Major Nidal Hassan murdered a bunch of soldiers at Fort Hood, right? His prosecutor was a very good friend of mine, a colonel in the Army who had done 2 capital cases previously. This was the biggest case in the history of probably in the history of the military. And he came down to talk to some of my students who were doing a class on ethics for prosecutors. And he was talking about the case, and he started talking about a captain named Gaffney. Gaffney was a 54-year-old National Guard officer who volunteered to go to Iraq and was one of the soldiers killed by Nidal Hassan. And for whatever reason, that individual was it touched Colonel Mulligan's heart that Gaffney lost his life, and the way he did it, because he tried to charge Nidal Hassan. And when he started talking about him, he started to cry a little bit. And he said to all of the students, you know what? I'm glad I did this because I cannot allow myself to do that in front of the jury. Because the minute you start getting, you lose your composure, you start getting angry, you start getting frustrated. What's happening, Stephen, is it's becoming about you. And nothing about this process is about you. It's always about the client you're serving. And that's why people like Rachel and Christopher and me can sit up here and be very kind of straightforward because we're dealing with a legal question. It's not about, do we like you? Do we not like you? Do we think we're right? Do we think we're wrong? It's an inquiry. And an inquiry in law is only effective if it's objective, right? Isn't that the essence of what we expect from courts? Objective inquiry into facts and law.
But I would like to add to that I find that there's an artificial, at times, distinction between emotions and passion and objectivity. And I think you need to be an authentic advocate. You need to keep your cool, but you can be passionate and you can bring your feelings into it. Feelings are very important. They're part of emotional intelligence, which is part of overall intelligence. And so, I just want to warn against, you don't have to be completely automatonish. You can be a passionate advocate, as long as you don't get out of control.
I don't want to suggest anything other than that. You just have to know your audience.
Right.
Yeah.
Right? If you watch the Derek Chauvin trial, you can imagine that if those prosecutors were allowed in a room alone with Derek Chauvin, they would have wanted to throw him against the wall and say, how could you be so inhumane? But they had to present it in a certain way. That's agency. You are an agent of somebody else's cause. So if you're going to use emotion, Stephen, you use emotion strategically. It's an asset. And there are times when you have to do it. And there are times where you have to be a showman or you have to be more aggressive with a court. But if you can't fit that into your strategic end state, then you shouldn't be doing it.
Yeah. And, Stephen, I'll add this too. The best arguments, appellate arguments I've ever had, I walk into the courtroom with my opposing counsel talking and having, and being social, and I leave the courtroom having with my opposing counsel being social. It's the arguments themselves. You do the arguments, but good lawyers and the good lawyers that I know all know each other. It's a very small world and they get along because you realize that you're making the arguments. Right. But you walk out of the room still being friends. And that's how it works.
What other questions you have?
I appreciate that thorough answer, I must say.
Campbell, Gabriella, any questions? Or Benjamin, either one. Questions for either one?
I do.
So,
have a
as a
question.
prosecutor, if you want, you can go ahead.
No, you should definitely go ahead.
As a prosecutor, has there ever been a case that you did not agree with the prosecution and did not want to prosecute that person, but still did anyway?
Good question.
So for me, I would change it a little bit. I never prosecuted a case I didn't agree should be well, let me take that back. When I started in the Army, it was still prohibited to be homosexual in the military. And one of the first proceedings I had to do was a proceeding to basically throw someone out of the Army because she was discovered as having a female love interest. And I didn't feel good about that. That bothered me. I didn't like the policy. I knew what my duty was. I was very grateful when it changed. I think the harder question, Benjamin, if you ever say to somebody, I think I want to be a defense lawyer, people will say to you, how can you defend somebody who's guilty? The truth is that's not that hard because what you're really doing is damage control. They might be guilty, but maybe not as guilty as the government says they are, right? It's very, very rare that a defense lawyer gets a truly innocent defendant, and that's a terrifying prospect. Nobody ever asks a prosecutor, how would you feel about prosecuting someone you were not positive was guilty? That's hard. And I did have some of those cases. They usually involved allegations of sexual misconduct, where it was basically a date rape. And I believed the victim. I believed we were doing the right thing, but there's always a lingering question about where the truth is. And again, The way you overcome that is to remember you're an agent. Your job is to zealously advance the cause of the government in a prosecution. Now, if you are convinced that you're prosecuting an innocent person, it is categorically unethical to go forward.
Mhm.
And you got to go to your boss and you have to say, I cannot prosecute this case. And one of my first cases, I thought I was there, and my boss said to me, are you convinced he's innocent? I said, I'm not sure. And the boss said, then your duty is clear. There's probable cause, you pursue the case, and you don't decide whether he's guilty. The court decides whether he's guilty. That's not common as a prosecutor. I think Christopher would agree, but it's not an impossible situation where you're in the midst of a case and you start to have these questions in your own mind.
Mhm.
That's not an easy thing to do. You have to remember where you fit. You're in this system. And that, by the way, is the point where you never want a bad defense lawyer. You always want a good defense lawyer, because in the end, you're going to have to live with the consequence of what happened. What I find highly disturbing are prosecutors who say, I'll charge everything I can charge because that'll get leverage to get a plea bargain. And what I always tell my students is, whatever you decide to charge, you better assume you're going to get that conviction and you can live with it. Because if you're charging people because you can and not because you think it's right, you've fallen into the trap of lawful but awful.
Mhm. Mhm. That's exactly right. And it is your job as a prosecutor to do what is just. And
Which I
that is-
find laughable too, because I think prosecutorial discretion is one of the biggest problems and flaws we have in our current American criminal justice process, and that we have unfettered discretion that is not exercised in a non-transparent way, and power is abused, right? And so we know what goes to trial. We don't know what didn't go to trial half the time. We don't know why someone's offered a sweet plea deal, why the next person isn't offered a free plea deal. Prosecutors are not required to explain their charging decisions to anyone. Here in Los Angeles, under our previous DA, we just had the most hotly contested district attorney's election in the country. But under the last DA, she instituted a program in which, for every use of lethal force by police in the exercise of their duties, when the DA's office made a decision whether or not to bring charges for improper use of force, the DA's office would release a memorandum. It was highly redacted, but a memorandum explaining their charging decision. That's woefully insufficient in my mind, but it's a good start, because that should be the same thing, same process for every single charging decision, not just the highly volatile police excessive use of force cases. So, but I think that's, I think it'd be amazing to have that across the country. I'd like a window into prosecutors' decisions, because once the sentencing guidelines, once legislators started to look at greatly restrict judges' sentencing power and freedom, the power shifted greatly. Prosecutors, what they discharge, what Professor Korn just told you, what they charge determines so much now. So we, the people, should have access to what they're charging and why, so we can hold them accountable. Sure, we elect DAs all over the country, but what are we electing them on? We're not electing them on fact-based decision-making, because we don't know what their decision-making is.
Well, and Rachel, like you just said, most people, this is the most important elected position that nobody talks about.
Yes.
No question.
So by the way, for all four of you, because I'm assuming you aspire to the profession of law. I certainly hope so after your performance, and it would be a due process violation if you choose not. But what this discussion should tell you is that when you become a lawyer, again, as a former soldier, the way to understand it is the law is a weapon system. That's all it is. It's a weapon system that's designed by society to produce positive outcomes. But Rachel and I know that a weapon system is only as effective as the competence, the honor, and the courage of the person into whose hands it's entrusted. So all this discussion about prosecutorial discretion, there may be problems with it, but what it does tell us is we rely on the competence, the integrity, and the courage of the people into whose hands that weapon has been entrusted to ensure that it does good for society. And the thing that that creates illegitimacy in the legal system is the public perception that the weapon system is being wielded improperly. So when you study, when you see yourself as a lawyer, I want you to understand that it's much more than just learning that what the Countess of so-and-so case did in 16 something. It's more fundamentally about character, right? Abraham Lincoln said what? Reputation is the shadow that's cast by your character. And so always be thinking in every step of your development as a professional, and you're moving into that phase in your lives now, that whatever is going on, be learning the lessons of character, because that's what makes the difference in the practice of law.
And Campbell, I know you've been patiently waiting to get your question in, please.
Well, it feels very narrow after the discussion we've just been having, but I know that you brought up the point, Justice Korn, about that all the tests will be clear and all the tests will be easy to use. So in that scenario, how would you go about making the argument that we should in fact weigh the tests, or that
You know, what was interesting and why I loved your last response, Campbell, is because if I had one kind of source of critical suggestion, it would be, don't forget that judges are not immune to policy considerations. They are cognizant of how their opinions are going to be perceived by the public. And it's not a decisive factor, but it may be a tipping point. So what that was to me, I think that was the pivot point, Campbell. That's where you could have said, look, whatever you decide, there's going to be a clear rule. But then you should be asking which of those clear rules serves the ultimate interest of our community better. And yes, the other side is right. If you don't treat this as a seizure, it could theoretically fall under the due process jurisprudence. But Professor Van Landingham made the point. What do you want to have to prove when someone grabs you or tases you and you run away? That they didn't have good cause to do it? Fourth Amendment reasonableness? Or that what they did shocked the conscience with all this complicated balancing of government interest versus intrusion into individual liberty? I know which rule I'd prefer. But more importantly, in the world we live in now, I think that's where you could say, talk about shock the conscience. I think most Americans would be shocked to learn that a police officer can shoot you with impunity and not have to worry about scrutiny under the Fourth Amendment so long as you run away.
Yeah, Jeff put that so well. And Campbell, I'll add this. I mean, one thing that I actually just argued and wrote about in my book that just came out was, as much as people talk about Obergefell and marriage equality coming in 2015, marriage equality actually kind of came in 2014. And why do I say that? It's because it was a point where the Supreme Court decided to not take a whole bunch of cases, and you suddenly have marriage equality in places like West Virginia and South Carolina. And a particular justice known as Justice Kennedy realized that it was going to be okay, and that the policy arguments had started to shift, that it would be possible a year later for a case to come forward where the court would rule that marriage equality would be the law of the land. So there's a lot more to this dance than meets the eye. And it's one of the reasons why I thought all four of you did such a good job today, because it is a dance and it's a process, and it's part of what makes being a lawyer so incredible as a profession.
Okay, so I'm curious where all of you guys stand on this issue. Are you for like common law seizures or seizures requiring submission? And why?
For me, it's easy. If an officer discharges a firearm or even a less than lethal weapon, a beanbag shot or a taser, they should be held to a standard of reasonableness under the Fourth Amendment. They should only do it if they can justify it with a claim of good cause, actual or reasonably apparent. So I'm not bothered by treating this as a seizure, because it's going to increase the scrutiny and ultimately the professionalism of use of force decisions, which is very important. I think leaving it to due process would open up a dangerous demise in the public perception of legitimacy of law enforcement and the relationship between their conduct and constitutional protections.
And it would be highly inconsonant, or it would be highly inconsistent with how common law as well as statutory law deals with self-defense for the rest of us. If it all comes down to reasonableness, right? I mean, if someone's about to hit us and we hit first, essentially, they're about to hit us. We have, reasonable belief they're about to hit us, and we strike first to keep them from hitting us. It comes down to reasonableness, whether or not we've committed a crime or we were justified in use of force of self-defense against someone. So that reasonableness concept isn't so crazy or isn't such a low standard. It's a standard that's imbued all throughout criminal law, and police officers should be held, I think, to the same standard. They should not be held to they could use force they can use any force up to that which shocks the conscience. No. They get to use force that's reasonable. Just like the rest of us.
Having said that, I think the opinion is somewhat inconsistent with Hodari. If I had just been reading Hodari, I would have questioned whether it would have come out the way it came out. But that may be actually some reflection of the subtle influence of public concern and public perception at any given time on the court. So
I'm with the dissenter. I'm with Gorsuch. Sorry. Jeff made a comment earlier about not all of us are persuaded by originals. He was talking about me, I think.
No, because all four of the arguments today, the first group and you, there was a very, very heavy reliance on and that comes from Hodari because Scalia wrote the majority opinion.
I honestly, I didn't have an opinion before I read the case. I was sort of back and forth. I think they're both hard positions. I put aside Hodari; it wasn't really at issue. I think Gorsuch had the better read of the common law history, and that's where I go with. But I think Roberts is probably more consistent with precedent, but for the reasons Rachel said, not entirely consistent with precedent. So I'm with the dissent, but I usually am.
I have a follow-up question then. How do you deal with I guess for all of you, how do you deal with seizure of objects versus seizures of people? Because that's been something we've been struggling with a lot.
I don't think there's much of a difference. There's a physical action that deprives you of autonomy over the object. That's the Look, if you read the footnotes in Jones, and we were pushing you guys on this, right? And equating the Jones placement of the GPS device as a seizure is patently inconsistent with the footnotes that Justice Scalia dropped when he talked about it, because he said that putting the GPS device on the car was clearly not a seizure because it didn't interfere with the petitioner's control and ownership, right? No. So for me, the question is, if you go back to property seizure law, it's actually a pretty good test you could have applied here. Has the government action resulted in a meaningful interference with the possessory interest over the item? Well, if that applies for property and I've got bullets in my body, I would argue that there's a meaningful interference with my possessory interest over my body. I think you could have used the K-row definition of seizure to bolster your argument.
So would you say that Ms. Torres's car was seized when it was shot?
No, because the shooting of the car didn't meaningfully interfere with her possessory interest of the car. It meaningfully interfered with the possessory interest of her body because she wasn't free to do whatever she wanted to do once she had bullets lodged in it.
And it wasn't a search like in Jones, because in Jones, it was the non-consensual touching. It was the physical trespass with intent to find information, versus here, it wasn't with intent to find information. It was with intent to physically restrain. And so that's where the intent comes in. And that's why it was the bullets in her body, not the car.
The motive. If you get a chance, go look at those footnotes in Jones. It's really great. You know, whether you liked him or not, Justice Scalia was a remarkable writer, and he could teach you in his opinions remarkably well. And that footnote is in many ways more important than the text itself, because it tells us that motive is everything. It's not just trespass, it's motive. coupled with the trespass.
Which is so interesting. I think that should be a law review article, Jeff. Maybe we could work on together, because the court in so many of its Fourth Amendment cases stresses it's the objective analysis, objective reasonableness. We don't care what the police officer thinks, except where we do. And their line of cases where they do is growing. And this is the latest one in that
But
line.
I'm not sure if I agree it's inconsistent, because I think the court is suggesting an objective assessment of that motive, just like the special needs cases, right? The Indianapolis versus Edmonds, the government asserts a subjective motive of protecting the public from drivers who are high, and the court applies an objective assessment of the asserted subjective motive. So
But they talk about the individual police officer's intent and motive doesn't matter. Here, the individual police officers, if they accidentally did that same thing to Ms. Torres here because of an accidental discharge, it would not have been a seizure according to their own.
But my point is, I think they're assessing that objectively.
Well, and that's where you and I have talked about, I don't think there is anything objective about their assessment. I think it's whatever they feel like that day.
What we did to you guys in this thing, we do to each other all the time.
All right. Mr. Hall's been patiently waiting. He's been our coach for a number of years, so I want to bring you in. Thank you so much again for your coaching.
Oh, absolutely. And I've got some teacher thoughts and some law thoughts, so please bear with me because I've got a couple of lines of thought here. First of all, thank you. This is the epitome of pro bono, and it's the type of mentoring that you don't have to do, but is so intensely valuable. It becomes flashpoint memories. I remember where I was when I first learned that I needed to be a lawyer, blah, blah, blah. So I appreciate that. As a teacher for the four of you, you did exactly what you needed to do. You got them to ignore you. Professor Korn and Professor Van Landingham just started ignoring you, and they argued on the bench over the law review article because you have triggered them to have this law discussion out. And when you get them to start ignoring you and going side by side, the Supreme Court at times forgets that there are counsel in front of them and starts to have that conversation laterally rather than horizontally. And that speaks to your brilliance. I have a personal question about the builds on bends. I chose not to be a lawyer because I didn't want to prosecute the innocent or defend the guilty. So if you'd indulge me, if you were speaking to lawyers of the Innocence Project in death penalty cases, right? Or addressing a team of lawyers who are addressing racial discrepancies in sentencing, prosecutions and sentencing. So much of this depends on the usage of the weapon system, to use your analogy, Professor Korn. That I get that question in the classroom if we get deep enough. And I'd like to know your opinion on that, because the Innocence Project has exonerated approaching hundreds of those accused, and they're predominantly African Americans or the poor or both. So as we evolve, and I absolutely agree with your argument that this case cannot be decontextualized from Hodari. It is a post-George Floyd case. It is in the contents of the Black Lives Matter movement. If you could speak to that briefly, and I know we're out of time, but how you would frame that for a teacher and for students. Thank you so much.
First off, and look, we get this question all the time from our students. Like, how can you be optimistic about this system when we see so much failure around us? I think one response is our legal system, it's an analogy to Winston Churchill's famous quote about democracy, right? It's the worst of all systems, except for all the others that have been tried from time to time, all right? It's got problems. What I try to emphasize to my students, Aaron, is that that justice is defined one client, one lawyer, one case at a time. If you want to make a difference, then you can make a difference in that individual decision. Those wrongful convictions were wrongful because there was a lack of integrity or selflessness on the part of prosecutors who refused to disclose exculpatory information because their egos were so wrapped up in the case that they couldn't stand the idea that they might lose or they might have to dismiss the case. Or maybe they just had bought into their own groupthink and they weren't able to look objectively. I think there's an analogy to what Rachel and I did in our prior careers, which was dealing with misconduct in war, like war crimes, right? you never get front page stories in the New York Times or the Washington Post that says soldier in Afghanistan put his life in danger to save child, right? The reality is, even when you deal with the Innocence Project, we have to remember that yes, there are wrongful convictions, and that is an absolute tragedy. As a matter of fact, I can't even imagine that the terror that would inflict. But on the other hand, there are a lot of rightful convictions. And there are rightful convictions because the system works. And what makes the system work, it's what I said before, Aaron. I never wanted to try a case with a lousy defense lawyer because I wanted to be able to sleep at night with the outcome. And I worried, and I had some, and I know Rachel did, where you almost want to grab your opponent and say, what are you doing? And you can't do it because you can't assume you know all their decision making. It is us. So when students ask me, especially with the issue of inherent bias and racial injustice, and what I do is I say, particularly with Zoom, this is one of the good things of Zoom, I look at the diversity of the students I'm looking at, right? So for today, look at the diversity we've had in the two groups. And I tell them in 1992, when I graduated from George Washington University, I could count on one hand the minority students in the class. And there were 450 graduates. So 450 new white, predominantly male lawyers joined the profession. That's changing. It's changing in the legal profession. It's also changing in the law enforcement profession. And I think that should give us hope, because the more we empathize with the reality of the society, the more likely it is that the law will be leveraged in a way that we can be proud of and believe actually starts to move to that statement on the top of the Supreme Court, right? Equal justice under law. I know Rachel has strong thoughts on it as well.
I mean, they're very similar to yours, Jeff. I think one of the things that law schools have often failed to do is point out the structural defects in the systems that we're teaching, because we're so laser focused on a narrow slice of the law in each particular course. But that narrow slice of the law is part of an overall system, and the system is human and the system is flawed and there are structural defects. So the question students have is, why should I become part of the system when I know the system is flawed? Then I'm helping perpetuate a flawed system. And that's where I'm going to say, well, find me the system that isn't flawed and go join that. You're not going to be able to do it. So you can make change without being part of a system, but you can also make incredible change within a system. And what Jeff said reminds me of that. I think it's a poem about, some little boys walking on a beach, and he's throwing starfish that are back in the water because they're about to dry out because the tide's gone out. And someone says to him, there's thousands of starfish. What you're doing doesn't matter. And he says, it matters to this starfish. So you can make change within your own arena. You can become a better advocate for legislative change for criminal justice reform by having worked in the criminal justice system, because you know what's going on. Prosecutors, people have once accused me of being very prosecutor friendly in class because I brought a lot of prosecutors in to come speak with the class. And I actually had defense counsel coming toward the end of the semester, but they hadn't bothered to look at the syllabus. But anyway, I'm like, look, prosecutors are one that have the most power. I love defense counsel. We need them. But the folks that hold the keys to the kingdom right now in our country are prosecutors. So you want to make the system more fair, I think you should become a prosecutor. If that's the case. So I think just awareness of the flaws, awareness of where you can make a change, awareness that there is no perfect system, and learning more about the system. We're all parts of different systems, right? But that doesn't mean that you lose your moral compass when you become part of it. That awareness, understanding, and education of the flaws helps you then advocate for change. And oftentimes you're more effective advocating change from inside. I mean, George Gascon, this incredibly progressive DA, was just elected. Very happy about that here in Los Angeles. He's facing incredible opposition, but he was a prosecutor. He was a cop. He was a police officer. So he can be a more effective change agent because he was part of the system as well. So that's right.
Well, it's so well put, Rachel. I'd say, I'm the first person that often will advocate about celebrating, the strengths of our constitutional democracy, but also recognizing its weaknesses, because if we don't recognize those weaknesses, we can't address them. And, Aaron, I've always been literally the only prosecutor among my friend group. Every other person I know is a defense attorney or a public defender. And I am exceedingly proud. My roommate from law school just got the death penalty repealed in Virginia. I mean, change is possible. She led the cause. She's a federal defender in Maryland. She used to be a public defender in Baltimore before she became a death penalty defender. I mean, change is definitely possible. And it's by having people in the system, as Rachel and Jeff just said, that make that change happen and advocate for that change. And that's not a small change, because Virginia and the death penalty have a tortured history. So, I think it's inspiring people to go in and be lawyers who we are counselors and we are change agents. And it's something that I'm always very proud of when it comes to my own students and talking to them, but recognizing that change is happening. And like Rachel said, Los Angeles, we're electing a new DA in New York. I'm currently here in San Francisco for work. They have a great new district attorney. There's just a lot of change is possible, but it's because of people like Ben and Campbell and Gabriella and Stephen looking at the legal profession and recognizing that they can make a difference. There's a lot to do. Jeff,
We do need to wrap up soon.
I actually need to go. I'm sorry. I have another.
So maybe. Yeah, please go ahead.
All right. I just want to leave you, Aaron, for your students with one story. We had an Army general who was a lawyer. He was a guy who was known as one of the smartest military lawyers ever. He was a one-star general. And he told the story about coming to the Pentagon one day, and they have a special parking lot for generals. And there are a lot of generals, you got General Electric, General Mills, you got all the generals at the Pentagon. So he parks his car, and he had to use his daughter's car. His daughter was a college student that day. And there was a Marine general that parked next to him, and the general got out and looked at his bumper, and the bumper sticker said, "Question authority." And the Marine general said to him, "Aren't you like an Army general, like a JAG?" And he's like, "Yeah." He goes, "Do you think it's appropriate that you're driving a car around that says question authority?" And he said, "I stopped for a minute, and then I thought about it, and I said, actually, yes, that's what lawyers do. They question authority." He said, "If the bumper sticker said challenge authority, I might have a problem, but it doesn't say that." And everything you're hearing, that's what your students, I think, need to learn, is that if you want to be an agent for change at the individual level, at the structural level, at the creation of law level, then lawyers are taught to instinctively look at a problem and question why it is. That famous quote from Robert Kennedy? Some people say, look at things as they are and say why. I look at things as they should be and say why not. Torres would not have been decided if there weren't lawyers who started the case by saying, I look at things that are and say, or why not? Why not change it? That's what lawyers do.
Wonderful. And I'll leave it there. Thank you all so much. The students can just sign off. I'll talk to the judges for a moment. But this is wonderful. This is going to be a close final round. Decimal points will separate you all. So I don't know how we're going to pick the top two teams, but we're going to have to find a way. But thank you all so much. And please keep in touch. You have my information.
Thank you so much.
Thank you so much.
Bye-bye.
Thank you so much. I appreciate it.
Thank you.
Thank you
Take
for
care.
the answers. Appreciate it.
Thank you. Well, thank you both. Here, let me turn the recording off, which I forgot.
If I
before.